Hi, everybody. Welcome to another episode of Psychology for Every Day. I am Dr. Laird Bridgman, your friendly neighborhood psychologist, coming to you today with a very special episode. I have an interview with a good friend and colleague of mine, Dr. Stephen Berger. Dr. Berger is a highly esteemed psychologist in our field, and he is fond of saying that he has the distinct privilege of being an et al. I'll put that on the screen for you, et al. It's Latin for meaning you belong to the group of everybody else. So in our field, if you're not in the field of psychology or sciences, generally in references to published literature, or in this case, legal cases, the lead author gets all the credit, and then everybody else is an et al. So the Great Eight was a group of individuals who back in the 90s, but actually started in the late 80s and then into the early 90s when I think in 1990 the first case was handed down in the California court system here. Probably one of the most influential, probably top 5 influential legal cases in our field, nationally and internationally. Because this particular case, CAPP versus Rank, so CAPP is the California Association of Psychology Providers, and Rank is Mr. Peter Rank, who at the time was the Director of Health and Human Services here in California. Basically, these individuals went to court to sue for psychologists' rights to admit and discharge patients from hospitals, from psychiatric hospitals. Before that time, psychiatrists did most of that, and they did not let psychologists have admitting or discharge. Couldn't write orders in a patient's chart, even though it was your patient. And that's a big deal. It's a big deal in terms of quality of care for our patients, but it's also a big deal in terms of being able to be paid for the services that you could provide your patients. So it was a landmark case. I thought it'd be interesting for everybody to hear the story from somebody that lived it. So without further ado, here's my interview with Dr. Berger. I hope you enjoy it. Okay, I'd like to welcome everybody to today's episode. We're with Dr. Stephen Berger, psychologist and colleague of mine at the Chicago School in Anaheim. Dr. Berger, I want to thank you for joining me today. I really appreciate you coming in and sitting and talking with us today about the CAPP versus Rank case and your involvement with that. I think not only is it a fascinating story, I think it's an important part of history that I'd like to make sure that we have documented for future generations, because it was such a monumental turning point in history for psychologists. So if you would just share your story with us, I'd be most appreciative.
Well, thank you. It's an honor to be here and a pleasure to be with you. The story, in one sense, is very simple. It's a legal case, and in this particular case, it falls in the category of a civil law case, although more specifically, it's administrative law. But any kind of legal case that you cannot go to jail is therefore civil. Criminal means you could go to jail. Just being right. Fined for things, it doesn't matter what a terrible thing you've done, such as refusing to rent your apartments to African Americans. That's not a crime, it's just a civil offense.
Right.
So the specific case that you have just referenced, CAPP versus Rank, more specifically stands for the California Association of Psychology Providers, and Rank is the name of Peter Rank, who was the head of the California Department of Health Services. In general, when you sue the government, you are suing a specific department who has engaged in some action that you're saying is inappropriate, and you therefore name the head of that department.
So he's the representative of the government and therefore kind of the spokesperson for it.
Yes, and specifically because he was the head of that department.
Right.
And we'll be talking about regulations that that department issued under his direction.
Gotcha.
But the full name of the case expands from CAPP versus Rank from CAPP et al. To rank et al. And personally, I don't care about the rest of their et als. I do care about our et als because those are individual psychologists.
Yeah. And who were those?
There were 8 of us, and I always try to do the names in the following order. The first name will not be alphabetical. That is Stuart Wilson, because he was the president of CAPP when the legal action was filed. So his name comes first. And now the names are simply alphabetical, if I can remember to do them alphabetically, although I did write them on a piece of paper that's over on the sofa. So we're going to find out whether my cognitive faculties are
still intact.
Going to last for minutes. So see if you can keep track for me.
Okay.
So the first name alphabetically is Berger. Me. That's the only reason my name is.
You're doing good so far.
So far. And then comes Larry Blum. And then Gary Bodner. Corey Fox. Steve Frankel. Lisa Pomeroy. Carlton Purbiance.
Help me with that last one spelling.
I'm going to spell it the way I pronounce it.
Okay.
Which is the way I spell everything in this world.
Me too.
Purbiance.
Okay.
Did I get all 8 of us, or did I miss somebody?
Yeah, and the first one was
Stuart Wilson.
Wilson, right? Yeah. Yep, that's 8.
Okay.
Nicely done. Your mini mental status score is 100.
Do I get to retire, or I got to
Well, you can be president.
try to tell the rest of the story?
Yeah.
So the story really starts in 1978, and the legislature determined that the people of California, the public, were unduly restricted in access to the services of licensed clinical psychologists in hospital settings, meaning hospitals weren't letting us work there,
Right.
even though we're independently licensed practitioners. And that's the beginning of the wording of the new law, which is a statute. When the legislature makes laws, those are statutes. And this statute goes by its number, 1316.5 of the Health and Safety Code, not of our license.
Yeah.
It's of the Health and Safety Code, because that's the set of laws that regulate hospitals, what they can do and not do.
Right.
And so in 1978, the legislature declares that psychology is an independent health profession, that patients were unduly restricted in access to our services in hospitals, and that therefore hospitals can put us on the hospital staff.
So before that time, psychologists were not allowed.
What hospitals would say is, well, there's no law that says you can be, and therefore some hospitals would say, therefore we can't have you on staff, meaning you can't provide services here. And other hospitals would say, well, there's no law that says you can't, and we like you, so you can. So this law was to clarify that, yes, we were entitled to be on the staff of the hospital. Because remember, when you're getting services at most hospitals, you're getting treated by a private doc. They are not employees of the hospital. They are independent practitioners who have privileges at the hospital.
Right.
Emergency room, it's a little bit different. They're still not employees of the hospital. Usually that is some medical group that the hospital contracts with to provide the services in the emergency room. And then in 1980, the legislature recognized that hospitals weren't really cooperating with this law like they really should. And so they modified the law to be explicit that if there was a service that that hospital provided that it's in the license of a psychologist or in a medical doctor, which is psychotherapy, psychological assessment, then either profession must be allowed to perform it without discrimination.
That's very clear language.
Yes, although if you read the actual words, it's a little bit awkwardly worded. I've tried to express it in simple English.
Right.
But we're talking laws.
Right.
So now we have the law on the books, but you need regulations to implement a law.
Okay.
Laws are not very specific about how they are to work. So the Department of Health Services, the entity that regulates hospitals, is now to issue the regulations to implement this law, to state how it is supposed to work.
Right.
And California law requires that when a government agency is making regulations that are major changes, they're not correcting spelling, they're not correcting grammar. When it's a major change to a law, they have to have public hearings. And so the Department of Health Services held public hearings saying one of these regulations is that clinical psychologists can make a patient's diagnosis and treatment plan. And Department of Health Services sent communications to hospitals saying, these are going to be the regulations, so get ready.
Yeah.
And then our attorney tells us that she saw the actual document that went from central office at Department of Health Services to the printer. Because until it's officially printed, it's not yet implemented.
Not yet implemented.
As law.
Right.
Okay. These are just physical technicalities.
Yep.
She said that she saw the actual document. Somebody at DHS headquarters decided they didn't like clinical psychologists being able to make patients' diagnosis and treatment plan. And they just redlined it out on the way to the printer.
Snaky.
Yeah. So now, in our opinion, meaning psychology's opinion, this regulation conflicts with the statute.
Right.
And statutes overrate regulations.
Yeah.
Right? Just so the Constitution overrates individual laws. And the California Psychological Association decided it didn't want to be suing the state of California. So a completely separate corporate entity got formed named the California Association of Psychology Providers, CAPP, CAPP.
Yeah.
And then there was a concern that does CAPP as an organization have standing to bring this lawsuit? So this is something that people need to understand about the law. When they say, well, anybody can sue anybody. No, not really.
Right.
You can try.
Right.
But one defense in court is that person doesn't have the legal right to sue me.
Right.
And one basis of legal right is called standing.
Right.
Which is an interesting term because you can be sitting down when you do
When you have standing. Right.
Right. You can have standing while you're sitting. That's one of the paradoxes of American law.
It's true talent.
Yes. And so I believe it was a Thursday afternoon when Steve Frankel, one of the plaintiffs whose name you heard a few minutes ago, walked across to my office. We shared office space. And basically said to me, Steve, a group of us are getting together a lawsuit against the Department of Health Services because they have this regulation that says a clinical psychologist cannot do the patient's diagnosis and treatment plan in the hospital. We don't think it's really any big deal, but just to be sure, we want some individual psychologists to put their names on the lawsuit. I wasn't doing anything else useful with my name at the time, so I loaned my name to the lawsuit.
Being in the right place at the right time.
Yes. And now I do believe that it's the second most important legal case in psychology's history. Jenkins versus United States, I rank is
number one. Okay.
Yeah. So now we're suing the Department of Health Services, and all the legal briefs are filed. And Now it's time for the trial. And our attorney, Michelle Licht, brilliantly says to the court, we don't need a trial. We just need a summary judgment. What is a summary judgment? Summary judgment basically means the two sides aren't disagreeing on the facts. What they disagree with is what is the law that applies to these facts.
Okay.
Was the Public Health Service regulation consistent with the law, or it's not?
Or it's not.
That's a legal opinion. That's
Right.
a judge, not a jury. Juries decide facts.
Right.
Judges decide what the law is.
Yeah.
And I once asked Michelle, when did you decide you were going to go for summary judgment? She said, from the beginning.
Yeah.
It's her legal strategy all along. And,
Pretty brilliant.
yes, and my opinion, not a lawyer, but in my opinion, Michelle writes brilliant briefs. I'll reference one in a couple minutes.
Okay.
So at that point, the California Psychiatric Association, the California Medical Association, the California Hospital Association wanted to submit an amicus brief. I do believe that's the proper Latin pronunciation, not amicus, amicus.
Okay.
Find an old Latin and correct me if you can.
I don't know any old Latins, so
So it's going to
It's lost
stand
the
for the
history.
moment. That's well chosen words, in my opinion.
I heard them from a brilliant man. So.
So they file a amicus brief with the court. And Michelle, in my opinion, writes a brilliant brief saying they are no friend of the court.
Yeah.
They're an interested party.
Yeah.
We've kept them informed all along, Your Honor.
Right.
If they wanted to be a part of the case, they could have been a part of the case, but they are not a friend. And the judge said, great, you don't have to take time to read that brief.
Wow. That really is a very brilliant move.
The entire court hearing takes less than 2 pages.
That
And it's basically the judge saying to the attorney representing the state of California, the assistant attorney general, saying to him, I think the psychologists are right. He says, well, the department thinks they're wrong. The judge says, I think they're right.
And it's the judge's opinion is the one that matters.
He's the only vote.
It's the only one that matters. Right.
Turns to Ms. Licht and says, do you have anything you want to add? No, I'm fine, Your Honor. Done.
Done. Nice. Nice.
I know usually the fish is this big.
Right.
I'm saying the fish is only that big.
2 pages. That's remarkable for such a monumental event, but it didn't stop there.
No. So now we have to have the written court order.
Okay.
And who writes the judge's order? Well, the winning party writes the judge's order. Judge doesn't get paid enough to write his own order.
Okay.
And at that point, we on our side are having a discussion about, well, what should that court order say? And I had the opinion that court order needed to say that we clinical psychologists could admit and discharge our patients.
Huh.
And at first, Michelle was saying, well, that wasn't a contested issue in the case. So I understand it's not contested in the case.
Right.
If this order doesn't say that,
Right.
then the hospitals are going to tell us, oh, you can do the diagnosis and treatment plan on your patient. How do you get a patient? You have to admit the patient.
Mm-hmm.
Well, you can't admit patients. There's no law that says you can admit patients.
Right.
There's no court order that says you can admit patients. This court order has to say that. And it does.
Wow.
And that was the first time that Michelle and I had extensive discussions, because up to that point, all my opinions went through Steve Frankel.
Oh, right.
He had
right.
a relationship with
And that was really the sticking point in psychologists being able to admit to hospitals previously, because it didn't say anywhere specifically that psychologists had to be allowed to.
Correct.
So that's why it was so important to have that in the
opinion.
opinion. Yeah.
Yep. Firm legal opinion.
Smart attorneys and good judges are key in the whole system, right?
Right. And so what are some of the implications? One of them, obviously, what we just talked about, that is you admit your patient, and now you get to treat them, and you get to do the diagnosis and treatment plan, which includes specifying how many days a week the psychiatrist gets to see the patient, how many days you get to see the patient, because most insurance won't pay for both psychiatrists and psychologists on the same day.
Oh. So things get complicated with the turf war over who's going to get paid.
Yes.
Yeah.
But if you're not the attending doc,
right,
you don't get to write the orders.
Right.
And you don't get to determine those things. In addition, when you admit patients to a hospital, you're bringing the hospital money.
Yeah.
So you're important to the hospital. And in those days, we're talking 1985 now.
Okay.
The hospital has a list of who's on active staff, meaning you've admitted enough patients to not just be on staff, but active staff.
Active staff.
Which also means you get a vote on hospital rules, policies, officers.
Wow.
And you get hospital referrals.
That's a big deal, financially.
Well, if you consider in 1985, $10,000, that's about what it was worth to have admitting privileges and therefore be getting referrals.
10 grand in 1980 was a lot.
Yeah.
Yeah.
Yeah. So this was very meaningful money for us. So now we write the court order. Department of Health Services has no issue with the judge's ruling and changes the regulation. And after the regulation's already changed, California Hospital Association, California Medical Association, California Psychiatric Association appeal our victory against health services. So that would be like I win a victory against you,
right?
And Joe says, I don't like his victory over Dr. Bridgman, so I'm going to appeal it. Bridgman's living with it, but I'm appealing it. The appellate court threw it out twice.
So they appealed. The appellate court threw it out, and then they appealed.
They don't have standing,
right?
Because they didn't have standing. This is between the psychologists and the in the hospital, and the hospital's Department of Health Services.
Health Services, right?
Right. Appellate court threw it out twice, and then the state Supreme Court said to the appellate court, hearing.
Oh.
Well,
so somebody put the big toe in it.
Supreme Courts are the authority.
Right.
They get to tell lower courts what to do and what not.
Yeah.
So now we're going to have a hearing because at the appellate court level, it's exceptionally rare that any evidence or testimony is taken. One kind of exception that people have become aware of is DNA. So there are cases now where DNA wasn't available at the time of the trial, and so that would be evidence that you could bring to an appellate court. But in general, appellate courts are just legal briefs, arguments.
Yeah.
No evidence. So now there's the appellate court hearing, and the appellate court says, well, yeah, basically the law does say that clinical psychologists can treat their patients at a hospital, but some patients have organic conditions, and so until the psychiatrist signs off that this isn't a physical condition or has to be treated by organic means, then psychologists can't be in charge. But once the psychiatrist signs off that it's not organic or not organic treatment, then the psychologist can be in charge. And so, of course, we know that will be never.
Never, right.
Be never.
Never.
So now we have to appeal that.
Right.
And that's when APA gets involved in that case.
Finally, they're interested.
Yes. Now they're interested, and now they're going to have to finance.
And this is a significant thing and finally of interest to them because that would, it's often said, right, that where California goes, the rest of the country follows on a lot of issues.
Yes.
Especially legal issues and mental health. And that's been the case for a very long time. And APA being aware that this would have ramifications in other states.
Indeed.
And so they wanted to then get involved to protect the larger interest, when before they didn't really see it was that big of a deal. Got it.
Right.
Okay.
And some of the people who formed CAPP were very prominent in APA.
Oh.
So I was not involved in the forming of CAPP. I just owned my name.
Right.
So that kind of surprised me that APA didn't take an earlier interest.
Yeah.
But now they could perceive that they had to try to save
They
this.
had to step in.
And so at that point, they provided the law firm from Washington, D.C. of Hogan and Hartson, if I'm remembering the name correctly. And I think the main attorney was Clifford Stromberg. I think I'm remembering that name correctly.
Okay.
So now we're working on writing the legal brief for the appeal. And there's a difference of opinion between APA and us locally. APA is thinking that we need to be attacking the appellate court ruling. And some of us felt that, yes, we have to address that, but the strength was really in saying the trial court got it right. Let's stand by the trial court.
Yeah.
And on a Friday afternoon, I was part of a fun conversation, us, people from APA. After the conversation, I get a phone call from Michelle saying to me, we need to come to a final agreement on Monday with APA. And there's a law firm that you in Orange County have been using and have been providing some private advice to me, and I need to talk to them this weekend. And so I got her in touch with Richard Sherman of the law firm of Irell and Manella, which was at that point in time the 86th biggest income producing law firm in America.
Wow.
And one Friday afternoon, I was in Mr. Sherman's office. He was their chief litigator. And there were only two cases he was willing to consider that Friday afternoon, overlooking Newport Harbor. Us and American Airlines.
Really?
Yes.
Do you remember what American Airlines was?
They had just bought PSA, I think was the name of that airline.
Okay.
And why did they buy PSA? Because they wanted PSA slots at John Wayne Airport.
The gates.
The gates.
The
Gates.
got a place park your plane somewhere, right?
If you're going to get people onto them,
right?
You got to park them somewhere.
Okay.
So I was in a class with American Airlines.
All right. So
they had
pretty
their
significant
conversation.
Yeah.
I was not a part of that.
Right.
And Monday morning, Select has a conversation with APA, and they agree. The emphasis in the brief, which you only get X number of pages.
Yeah.
I think the longest legal briefs that I'm aware of, a court allowing, is 50 pages, and 35 is often the limit.
Yeah.
So just like we try to get students' dissertations over 100 pages, that's always my goal.
Right. Yeah.
No, courts tell you, we're only reading this many pages.
Right.
So the brief goes in, and now we're waiting to see if the California Supreme Court will accept the case for review. And as I understand it, at that point in time, I have more recent statistics that the California Supreme Court accepts about 1 out of 10 cases, about 10% of cases that they are asked to review that they review.
So pretty low rate of review on that. Okay. So for every step in this sequence, like the odds against any one step actually succeeding or the deck is stacked against it the whole way.
Yes.
So it's kind of remarkable that everything lined up. Like it's all like the lining of the planets. It just it was kind of a magical thing.
Well, a lot of people came together.
Yeah.
I'm primarily emphasizing my own contributions because those are the ones I know the best.
Right.
But everybody made contributions of one sort or another. I do accept I made some particularly meaningful ones. I do accept that, but there are a lot of people ultimately involved.
Well, I think it illustrates the importance of being proactive and being involved whenever there's an opportunity that is around you and you have a chance to step up and step in. It might be really important to do that.
In whatever way that you can.
Right.
Not everybody's going to get their name on a legal case, and after all, at this point, I'm really an et al.
Yeah.
There aren't that many people
Right.
that really are associating my name, but it's
Right.
pretty cool to be an et al. I mean, you could be worse.
I'm not an et al, so
And I've been called worse things. So,
right.
but I think part of the point that you're making that I'd like to support and reinforce is you begin graduate school, you have no idea that you're
Right.
going to be involved in anything of consequence, or
Yeah.
that you're going to have some theory that it's going to be named after you. You just don't know.
Right.
And continuing that concept, sometimes you can support by making donations. Sometimes it's just personally supporting somebody who is involved.
Mhm.
We all don't have to be on the front line, but it's hard to be a lone ranger. And
Right.
even he had Tonto.
Right. Indeed. Right. It's hard for anybody to get anything done all by themselves completely, right? No person is an island. One of my faculty mentors had said to us in our one of our first year classes, he said of the next great works in psychology, if not you, then who? And if not now, when? And it's that same principle that, when the opportunity is there.
Right. So without being arrogant, let's not underestimate ourselves either.
No. The importance of the significance of your event does not make us greater than anybody else or more important than anybody else. It just means that we played our role and our part at the time. And being in the right time, in the right place, is an important thing.
Yeah. And so on a Tuesday, I get a phone call from Michelle saying the California Supreme Court has agreed to hear the case. And then there were some other issues we still had to work out with APA, and I said to Michelle, so that gives them till Thursday
Because,
to agree to what I think they should agree to.
mhm,
And they did.
and they did.
So here's an interesting quiz question for you.
Okay.
Because there's laws about everything.
Mhm, right.
Once the California Supreme Court has agreed to hear a case, according to law, by when must they hear it? How long do they have?
I have no idea.
1 year, 2 years?
There's a rule about it, I'm sure. But I have no idea.
There is.
There is none.
Man, just because they've agreed to hear it doesn't mean they ever have to get to it.
So there's not one.
But once they hear it, they have 30 days.
But they have 30 days once they hear it. Okay.
But they never have to hear it. They're busy.
Yeah.
Stuff comes up.
Right?
Right?
So they can always push it down the calendar.
Yeah. We never get to you. But now we have to write the legal arguments.
Right.
Plus, again, it's not evidence. You get to file a legal brief.
Right.
And I was allowed to express some opinions about what should be in the legal briefs. And one of the points that I kept stressing, it's for interviewing me,
Mm-hmm.
one of the points I kept stressing was, as crazy a decision as we think the appellate court made, they didn't say we were wrong about the law. They were talking about how to implement it. And so, speaking as a psychologist, psychologically, Supreme Court, no judges have said we are wrong about the law. Psychologically, no one's disagreed with us.
Right.
And the trial court got it right.
And that's the whole brief, basically.
Wow, there's a lot more in there.
Right. But essentially, that's the key argument, right?
I think it's a important psychological argument.
Yeah.
There's a lot of other
Right.
legal arguments to make in there. And if we had a lot more time,
Right.
there's interesting things about medicine's brief that
Okay.
I make those points on other occasions.
Okay. We'll do a separate video on that one. Tune in for another episode later on.
Or yes. And now the night before the hearing is to occur, we have a dinner that APA has put together.
Mhm.
And at that dinner, I'm being my usual self, and I'm stressing that particular point to the attorney from APA who's going to do the oral argument. And now we are in Los Angeles, in the courtroom. Out come the judges, 7 of them. But wait, that judge isn't on the Supreme Court. He's from an appellate court. What's that all about? Well, one of the Supreme Court judges had been on the appellate court that had made that ruling that we were appealing. So he had to recuse himself. But they wanted to have 7 of them. So they elevated we're paraprofessionals compared to psychiatrists.
Right.
They elevated a paraprofessional judge, appellate court judge. And he ruled in our favor.
Well, we love him then.
Yes. But the paraprofessional judge ruled with the paraprofessional psychologist. Right?
That's hilarious.
So Justice Mock was the Chief Justice, and he begins by saying, I was going to start by saying, this looks like a lovely day. And then I thought about who my audience was. I thought, oh, I wonder what I mean by that. So now Mr. Stromberg gets up to begin his oral argument. And he's reserved 5 minutes of his 30 to go at the very end.
Tim.
Now, you'll remember we talked a little bit earlier where I had said in 1980 the law got modified, 1316.5,
Right.
to say that if a service is offered by a hospital that is in the license of a psychologist or psychiatrist, that either must be allowed to perform it without discrimination.
Right.
But this is 1990.
Right.
And we're thinking, we don't want to put a lot of emphasis on the word discrimination. Don't know how these justices are going to feel about that. We want to talk more technical legal arguments.
Mm-hmm.
So we're shying away from that word. Mr. Stromberg is maybe 10 minutes into his argument. And one of the justices says, and so isn't that discrimination that would be going on? And doesn't this law say no discrimination? So I ask you,
90s.
the ethnicity of Justice Broussard?
Oh. So I got
Yes, he's African
I got to
American.
think African American. Yes?
Yes.
Okay. Right.
Yes, the
Yeah.
African American judge gets discrimination
He gets it.
issues.
Right.
And he's basically making our case. It's almost like, yes, you're right. Yes, you're right.
Again,
Yes.
the planets are aligning in all of this. I mean, that's just like, what are the odds that that would be true?
Right. So you have all this effort that's gone into constructing the written oral argument. 10 minutes in, that's over with, and now it's questions and answers extemporaneous.
Wow.
So now we're at the 25-minute mark. Mr. Stromberg has reserved his 5 minutes. So now it's the other attorney's part. He's making the argument for medicine, why they have to be in charge of every case in the hospital, and we're just not competent to be able to be in charge of our own cases. And years later, when he retired, and he was asked, what are cases that you really regret losing? He said, this one.
This one.
I have
Wow.
no passion for him. he finishes, and now it's time for. He got about 5 minutes into his
Yeah.
presentation, and the judges were interrupting. And so much for his structured material. You got to come prepared.
Right. They weren't interested in the rest of it.
And now Mr. Stromberg gets up for his last 5 minutes. And one of the things he says in that 5 minutes is, and no court, no judges have said that the psychologists are wrong.
I'm wrong.
Our issue was just the appellate court's application of how it should work.
Wow.
Yeah, so I feel very good about that.
And so then that was the decision.
That was the decision when it came out. And when the court makes its decision, it's in writing.
Okay.
And each of the attorneys are sent by the court the official decision. And that looks like this.
I will put a close-up on the screen for everybody to be able to see that. What's the date stamp there?
Supreme Court filed June 25th, 1990.
1990.
The clerk's
And so this whole journey started when?
1984 with CAPP,
Right.
and 885 the lawsuit.
So 84 to 90. So the better part of 6 years.
In this decision are these exact words. We believe the trial court got it right.
Got it right.
So yes, I feel very good about all
Wow.
those details.
I mean, what a journey. I mean, it's such a long one, from start to finish for like one issue to get cited. And then each round, you think it's done and then it gets brought back up again. And of course, it's not until you have a Supreme Court ruling where you can actually exhale and say, okay, it's fine. It's finally done now because the California Supreme Court has said so. So that's kind of the end of the road at that point, right?
Okay, everybody, listen, thanks for tuning back in. I hope you enjoyed that interview with Dr. Berger. And if you've made it to this point in the video, I want to thank you so much for sticking through the video till the end and listening to all that. It really helps the channel. And if you have not already taken a moment to smash the like button, please do that. And hit the subscription button so that you don't miss any of our future posts. We have a lot of plans for this year. So a lot of interesting content should be coming the way. So thank you for tuning in. And as always, until I see you again, make it a great day.